Elements of a crime. In order for something to be a crime, it must first be defined by law. Legal definitions of crime are made up of elements. The elements of a crime are the component parts that make up the crime as it is defined by law. Each of these components must be proven beyond a reasonable doubt before a defendant can be found guilty of that crime. There are several different categories of elements of a crime. Each crime is defined in terms of these elements, but the law defining a crime does not always have to have each of these. The first type of element is the actus reus. This is the physical or active part of the crime. The actus reus is a voluntary act that causes some social harm. So what does this mean? First, it has to be a voluntary act. Usually, this is a required, if implied, element of a crime. It is unusual that a person can be guilty of a crime without having committed a voluntary act. This is distinguished from a thought or a state of mind. This physical act might include pulling a trigger, making a threatening statement, or driving under the influence of alcohol. Sometimes, though, this action can really be inaction. In a limited number of circumstances, failure to act is a crime. For example, Nevada law requires physicians to file a report if they have reasonable cause to suspect child abuse. Failure to make this report is a crime of omission, and it is a misdemeanor. The act, or failure to act, must also be voluntary. This is not necessarily the same thing as intentional or on purpose. For example, engaging in negligent action is considered a type of voluntary act. But it would be quite unfair to punish people who did not choose to engage in activity and who aren't morally blameworthy. But for the purposes of actus reus, the types of actions defined as involuntary are quite limited. Generally, we assume that people who are unconscious, asleep, or having a seizure are engaged in involuntary actions. But that doesn't even mean that all actions committed while in these states is involuntary. For example, a New York case from the 1950s, People v. DeSena, involved criminal negligence of a man who had a seizure while driving. Several children on a nearby sidewalk were killed as a result of the accident. But the appeals court upheld the conviction because the driver was aware of his condition before the accident. But the court has found that the state cannot make it a crime to have an illness or even to be an addict to illegal drugs. It's fine to criminalize the act of buying, possessing, or consuming drugs, but not to be an addict. The voluntary act must have a causal relationship to the harm defined in the statute. There is a complicated set of rules to determine whether and how much a defendant's action contributed to the resulting social harm. But this relationship does not need to be an immediate relationship. Take, for example, the shooting of Sergeant Ira Esso in 1980. He was paralyzed when he was shot by burglary suspects, and the two suspects were convicted of attempted murder. When Esso died in 2010 from complications of paralysis, the two men were charged with murder. In this case, the defendants challenged the charges because, at the time of the shooting, California law defined murder as a crime that led to the victim's death within 3 years and 1 day of the incident. But California has since done away with that time limit, as have many other states. Finally, the actus reus requires that the voluntary act result in a social harm. This is a harm to society in general, although it is often a harm to one or more individual people as well. Obviously, the social harm might be a particular harmful or undesirable result. For example, if a gunshot leads to someone's death, the death is a harmful result. But a socially undesirable result is not always required. Sometimes, a certain type of conduct is defined as harmful in and of itself. For example, drunk driving is a crime, even when it doesn't result in the violation of other rules of the road. The same is the case for prostitution, which is a crime in and of itself, even in the absence of any specific harmful result. But sometimes, additional circumstances are required for the conduct or result to constitute a social harm. These are called attendant circumstances. These are basically the other relevant facts of the situation that make the crime a social harm. These facts are usually determined not from the point of view of the defendant, but from another point of view. These facts can define the crime, or they can define the degree of the crime or the severity of the punishment. An example is the crime of burglary. In many jurisdictions, burglary is unlawful breaking and entering into a home at night. This means that an attendant circumstance of the crime is that it must happen at night. Other sentence enhancements work on a similar principle. If one uses a firearm in the commission of a crime, that can trigger an increase in the severity of the crime and in the punishment. The second main element of a crime is the mens rea. This is the mental element of a crime. If you've seen the movie Legally Blonde, you might be familiar with this term from the awkward moment in this courtroom scene. There are many different types of mens rea requirements, and criminal statutes include the specific requirements for each crime. Here is a list of some of the most common mens rea requirements. Some crimes require that the defendant has acted willfully or purposely. This means that the person made a conscious decision to engage in conduct or cause a particular result. There is also knowingly, which means the person was aware of the nature of his conduct or the existence of circumstances and was aware that his conduct will be practically certain to cause the particular result. A reckless standard requires a conscious disregard of a substantial and unjustifiable risk and a gross deviation from a law-abiding standard of conduct. There is also something called criminal negligence, which means that a person should have been aware of a substantial and unjustifiable risk and a gross deviation from a reasonable person's standard of care. Criminal negligence is a common standard in child endangerment statutes. You might remember the recent case of Patricia Krenzel, who was accused of taking her 5-year-old daughter to a tanning salon, resulting in a sunburn. Her child endangerment case is currently in front of a grand jury in New Jersey. These cases don't require that the accused know and disregarded a substantial unjustifiable risk, but only that they should have known that such a risk existed. But there are some types of crimes for which there is no mens rea requirement. These are strict liability crimes, which means that the defendant's state of mind does not matter in determining guilt. Usually, minor infractions take this approach. One example is a parking ticket. It doesn't matter whether you intended to park in a no parking zone or not. It doesn't matter whether you knew or should have known that you were parking in a no parking zone. If you are in the no parking zone, you will get a ticket. A judge might show compassion for you if you have extenuating circumstances and maybe lower or remove the penalty, but that doesn't change the fact that you were guilty. Another example of a strict liability offense is statutory rape. There is no requirement that the defendant had a particular state of mind or intention. If the attendant circumstances of, number 1, sexual relations occurred, and number 2, one of the parties was under the age of consent, then statutory rape is deemed to have happened, regardless whether the defendant knew or should have known of his partner's age. So these components make up the elements of a crime. These are the elements that are used to define each of the laws on the books.